concept of data breach, and along with that the concept of penalties. The kind of penalties obviously being imposed under the data protection law are exorbitant. In Indian law, honestly, we have never seen this level of penalties ever being imposed. So a fair understanding of that, the penalties alone can actually show the kind of impetus that the Indian government is going to give to data protection in India, the value of data, how data being exploited can actually risk human lives. That is also a fact with the number of cybercrime cases, risk people's finances, which we have seen with financial crimes also happening online. So yes, the data protection law gives a good adequate value to this loss that is happening to individuals and organizations by misuse of their data. So when we are talking about penalties over here, now in the case of an organization or an individual who is breaching the norms or the you could say the provisions of the data protection law, and the data fiduciary or the data processor, if he fails to go about protecting the data of an individual or identifiable data of any organization, HUF, firm, etc., with whose data he is collecting or processing, he is liable to a fine which would extend up to 250 crores. Now that's a very huge fine you wouldn't have seen in any law in India. Now, when you're talking about a data fiduciary, who is that being referred to? A person or an individual who decides how the data is going to be collected, whose data is going to be collected, and how it is going to be stored and how it's going to be processed. Who is a data processor now? A data processor is the organization or individual actually performing the acts on the data. The acts of storing the data, the acts of categorizing the data, the acts of transmitting the data, the acts of maybe running automated processes on the data. So any activity which is happening, whether it may be physical or digital on the data, being performed by an individual organization is called the activity of a data processor, and the person is designated as a data processor. So the kind of liability associated in case of breach of data and provisions of this act which leads to data breach, provisions of this bill which leads to data breach is to the tune of 250 crores. The second level of penalty is the breach in observing the obligations to give the board or the affected data principals a notice about a data breach. So right now, if you see in India in organizations, when a data breach happens, certain is supposed to be notified of the same. However, 90% organizations really do not file an FIR. They don't notify certain. They don't notify even the regulator. So if they're a regulated entity, like regulated, let's say under IRDA or RBI, they're supposed to notify the regulator also. So currently that is not really happening. So under this data protection law, the Indian data protection law, the failure to notify the data protection authority which is appointed, the board which is appointed, and also all the affected data subjects. So in the case of a data breach, you need to notify every single subject whose data has been breached, and the failure to do this leads to a penalty or a compensation penalty which is up to 200 crores. So very huge figures that we're looking at, and this is per instance of data. So if the data is involving multiple users, then yes, there could be a larger penalty also involved. The third penalty being a breach in observance of the duties of a significant data fiduciary. So where an organization or individual is handling sensitive personal data and information of a considerable population, or offering goods and services. So where it also applies to organizations or individuals outside the country who are offering goods and services to Indians inside our territorial boundaries, and they are processing sensitive personal data and information, then in that situation, up to 150 crores is the kind of penalty if they breach the provisions of the Indian data protection law. Breach in observance of duties towards a data principal or a data subject. A data subject is, let's say, an individual, a HUF, a firm, an association, or a corporate, incorporated entity, which could be like a company, an LLP, etc., whose data is being processed or collected. So, in this situation of breach in observance of the duties under the law, which we are going to see in the next module with the next capsule on this subject, which will be there in this series, up to 10,000 rupees is the kind of penalty. In the case of breach of any other provisions of the data protection law, The same being in the nature of failure to give consent, failure to record consent, failure to amend consent, management of the entire consent concept, and failure to have adequate cybersecurity, data security in an organization to protect individual data, organizational data of data principles. The penalty is up to 50 crore rupees. So if you see the entire range of penalties out here, it's starting from something like 10,000 rupees going up to 250 crore rupees, which is amongst the highest penalties ever considered in Indian law, ever been put into any legislation. So that in itself shows the level of seriousness accorded to the data protection law and the data of individuals. One of the reasons in my thought process why these kind of penalties are involved is because misuse of individual data has serious ramifications. There have been multiple cases of data breaches involving applications which are gaining access to individuals, microphones on the cell phone, cameras remotely switching on, recording personal recordings, you could say video recordings of their personal moments, a lot of things that are happening which can actually jeopardize individuals' lives. There have been multiple cases of data breaches in hospitals that have happened, which can again affect human life, where manipulation of such data comes with the risk of the fact that, there can be wrongful diagnosis, wrongful medication. Again, financial losses that happen with respect to data breaches where your sensitive banking information is disclosed. There are applications today which are in the nature of malware in, you could say, routine applications which you have on your cell phone which you're downloading, which if the cell phone, which the applications online, like let's say which you've downloaded, which may be shopping apps, which may be apps for any other service being provided to you, if they fail to have adequate cybersecurity, if they fail to protect your data, they do not have adequate safeguards. The risks coming in out here being that, there could be malware which is through these applications on your phone can end up even accessing and viewing your financial information, which includes OTPs for transfer, your OTPs, it can access your banking information, banking applications, and the kind of risks involved being tremendous, and your savings, your money being at risk. So yes, it's a very positive step taken wherein the penalties are so high and data of individuals being given value under this law. So stay safe, stay connected, and yourself, your organizations work towards data protection.